And of course, it's also possible that they affirm Judge Jones's decision and that the case ends up back in state court. The other lingering question with removal, of course, Ben, is also whether Trump will file a notice of removal. He has not, but the clock is ticking. Steve Sadow, who is his attorney in Fulton County, has been at all of the removal hearings that I've been to for Meadows, for Jeffrey Clark, and also for the fake electors. And they have until 30 days after arraignment to file that notice of removal. I believe that the date that Trump filed his arraignment waiver and entered his not guilty plea was August 31st. So it's within the next few days here that we should see whether Trump will file that notice of removal.
I'm Benjamin Wittes, and this is the Lawfare Podcast. September 30th, 2023. It's another episode of Lawfare's live Thursday show, Trump Trials and Tribulations. A tour around 4 courts. This one with Scott Anderson, Anna Bauer, Roger Parloff, and hosted by me. We talked about what's going on in Fulton County. We talked about that judgment against Donald Trump and the Trump Organization in New York. In the civil case from Letitia James, we talked about Tanya Chutkan's refusal to recuse herself. And we talked about SIPA classified materials in Mar-a-Lago. It's the Lawfare Podcast, Trump Trials and Tribulations, a trip through 4 courts. We have a packed week of stuff, and it's all happened in like the last couple days, because when we talked the other day about this episode, we were like, man, there's not that much going on. But no sooner did we say it than the New York State Supreme Court, which is a trial court in New York, decided to put the Trump Organization out of business. So, Scott, this is a civil judgment. I guess it's more part of a tribulation than a trial, since it was a pre-trial summary judgment motion. How big a deal is it? And what is the effect going to be? Is Trump Tower going to be renamed Letitia James Tower, as the meme going around the various online services has it?
Yeah, it's a really interesting case. I'm going to caveat all this by saying a New York State civil case is a little bit out of my usual lane as our international lawyer person. So I'm pinch hitting a little bit, and I've read in on this a little bit, but there may be limits to my knowledge. But it's a really interesting case, and it's a phenomenal read. This is an opinion that came from Judge, I want to say Erdogan, but that's actually mispronouncing. Let me make sure I have the right spelling here. It's very close to Erdogan.
Yeah, it's Endogan, I think.
Endogan, thank you. This is what happens when you ask the international lawyer to come in and talk about state court proceedings. Judge Endogan issued a decision 2 days ago, essentially providing summary judgment on some of the counts that Attorney General Letitia James had brought in this civil suit. The civil suit generally alleges that former President Trump and an array of businesses and business associates of his were engaged in a systemic process of fraud where they systematically misrepresented the value of a whole range of estates, among other sort of casual claims, but really, really numerous property-related claims about valuations, and did so to underrepresent or overrepresent the value of that estate for various purposes. So for tax purposes, for mostly using them as collateral or seeking insurance on them, overstating their value in various ways. Has been ongoing for several months now. We've seen a series of litigation over different types of subpoenas the Attorney General's office had issued regarding the suit. We actually saw a decision go through Judge Endogan and through the appellate court in New York come down this past summer. We actually just saw in the last 30 minutes another decision come from that court, which I'll get to in a minute. This opinion that came out a few days ago from the trial court says essentially, look, I'm finding for summary judgment, I mean, we're not even going to bother going to trial on a huge swath of the fraud claims. These are claims about the systemic pattern. And it says as a remedy, essentially, in addition to potential fines and other things that might come out later, I'm revoking a series of business licenses for a lot of the corporate defendants and for businesses owned by a lot of the named real person defendants.
So before you go on here, I just want to pause over the issuance of summary judgment in favor of the plaintiffs. You don't see that very often.
No.
Usually summary judgment, because in a summary judgment motion, you have to construe the facts as favorable to the non-moving party as possible. And you have to be able to say as a judge that there is no way to construe the facts and evidence in which Letitia James does not win. We saw that happen in the Dominion Fox News case, which was even more extraordinary because it was a defamation case where the liability standard is so radically constrained. But this is now another case, and one involving Trump, in which, they basically said there's no way a jury cannot find for her. And I'm just curious for your thoughts on that, and whether you think it's as extraordinary as I do.
It is pretty extraordinary. I don't know enough about New York, judgments under this standard, what their general court, what their approach of review is. I'm familiar with the federal standard. In a federal court, this would be pretty remarkable, not unheard of, but pretty remarkable. I mean, again, it would show that there's no dispute of facts here that's sufficient that a jury could reasonably find to the contrary. And the judge is not shy about explaining why. I mean, he basically points out in a variety of these estates cases where the Trump administration has been shown, Trump and the Trump organization and various other defendants have been shown to have a series of estimates of the value of certain properties, and then to have filed estimates that departed from them wildly in directions in favor of those defendants, sometimes to the tune of like 600 or 700% of the value. The judge says easily, you could have differences of opinion, errors that might lead to a 10% or a 20% or maybe a 50% or maybe even in some exceptional cases a 100% departure from the estimate given, but several 100% in a direction that favors you systematically over a whole array of properties over multiple years of conduct, although the claims themselves only go back to 2014 for statute of limitations reasons, is pretty remarkable. And that appears to be what the judge is hanging his hat on. We'll see what happens on appeal, but it's worth noting we just saw the intermediate appellate court rule in this matter in the last 30 minutes or an hour or so. There had been an outstanding motion where Trump and his attorneys had said that Judge Erdogan had improperly applied an earlier intermediate appellate court ruling from the summer that, in their view, should have withheld certain testimony, and by virtue of withholding that testimony, essentially wiped out a lot of these claims. The appellate court, in a kind of 2-page ruling, which I haven't found a copy yet because it just happened, but as described, it's a 2-page, very succinct, concise ruling, says essentially, the trial court had it right. So at least they're not biting onto some of these more assertive or aggressive claims that Trump and his lawyers seem to be making. Now, this is still going to go to a hearing on October 2nd, I believe it's scheduled. There are still other claims that have to be resolved. Until then, it's also a little unclear what the remedy the court has issued is. There essentially was already a retired judge who was serving as kind of an overseer of certain corporate business practices in this case and had filed a report indicating that there were still some problematic things that were happening even under her independent supervision. She is now still in charge of these sorts of actions. And again, he's issued essentially an injunction saying these people aren't allowed to do business here. I'm repealing certain certificates that allow them to do business here, and these people aren't supposed to be involved in a lot of these business practices. Trump's lawyers actually came back the next day, asked for clarification on this, saying, like, are you saying we need to sell all these properties or that we just can't be involved in managing them? The judge said he wasn't ready to issue a ruling on that at this point. So it sounds like it's more that they are supposed to be operating under, I guess, the authority of whoever's left at these organizations or under the supervision of this independent observer. But regardless, it's a pretty significant barrier to Trump and a lot of his affiliates doing business in New York, at least temporarily until the broader resolution of these matters. And if the summary judgment stands, obviously there could be permanent damages owed. Attorney General James had asked for $250 million in damages, but there could be much more in the offing still.
And when you say there's still some matters that are going to trial, what delineates the stuff that the judge did rule on from the stuff that is going to trial?
It's a good question. I think it is a certain defendants and then certain types of claims. So the claims that they're specifically addressing are fraud claims under a certain provision of the executive law, which is kind of like a corporate governance law of the state of New York. I take it, again, not a New York state law expert, so apologies. Maybe there's one on here who can weigh in and clarify. There are other claims of the initial complaint, which I believe is still the current complaint, about falsifying financial statements, different sorts of other types of fraud separately related from just these property claims. So it seems to be just a subset of the fraud claims. My suspicion is that a lot of these other arguments have much more to do with questions of intent, mens rea, individual things that may vary from defendant to defendant. Whereas this particular fraud claim, the way the judge described and structured it, at least the way he understood it, is that it's closer to strict liability. Like, you're filing false statements. You seem to have evidence of knowledge that's sufficient to show you knew they were false, and that's sufficient to trip the line on this particular set of claims.
All right, so we are going to do a heck of a bounce around here because different people on this Zoom have read different filings in different courts. It's not a easy delineation where, like, Anna has Fulton County and Roger has DC. So we're going to bounce around a bit. Let's start with Judge Chutkan. Roger, you predicted last week that Judge Chutkan would not recuse herself and that argued that the motion for recusal was very weak. Judge Chutkan has now issued 20 pages of ruling on the subject, of which I have read 0. Were you right?
I was right. And
it's the 3 most fun words to say in all of journalism.
Yeah, and pretty rare ones too. But and it's a good ruling, and I think it puts this to bed. It's like you said, 20 pages. One of the nice things about this ruling is it's very understated. It's very dispassionate. She controlled herself. She didn't get angry. There's no sarcasm. There's no lashing out that might look like bias. If you remember, the issue was that she had said a couple things in 2 sentencings of January 6th defendants that Trump took issue with. And the main one involved a case where she said the words, she was describing what the defendant had done. And she said, it's a blind loyalty to one person who, by the way, remains free to this day. So the Trump's lawyer said, well, the clear implication of that is that she wants him imprisoned. And so she's biased. And, you know, if you were looking at this out of the blue, you could almost say, well, I don't know, maybe so. Because the standard is under 18 U.S.C. 455A, any justice, judge, or magistrate judge of the United States shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. Now, the thing is, as she points out very calmly, there's a lot of glosses on that, including, most importantly, a Supreme Court ruling in 1994 that's very clear that ordinarily they make a distinction between intrajudicial statements and extrajudicial statements. Statements made in court about a subject before the judge are almost never, and those are Justice Scalia's words, almost never going to warrant recusal. And so that's where it begins. And then what she says is she goes through very meticulously what was happening here. The 2 defendants were being sentenced. They pled guilty. What they had done was stipulated to. The prosecution had presented videos during the sentencing, and the defense lawyers had made arguments, and their arguments had been 2. First of all, I was there at Trump's behest. You should be lenient for that reason. And also, there are people more culpable than me, the organizers and everybody else, that have not been charged. And you should take that into account. Why should I be sent to jail when all of these more culpable people. And so she was addressing those arguments. And in that context, she was saying, yes, you're right about this, but still there was a mob and you were part of it. And then she explains that the sentencing statutes and the case law require her to do this. She has to, it's part of her job, is to go through the arguments that are made by the defendant and to say, well, the degree to which you're giving them credit, the degree to which you're discounting them, and why. And so she said, a reasonable person aware of the statutory requirement that the court address the defendant's arguments and state its reasons for its sentence would understand that in making the statements contested here, the court was not issuing vague declarations about third parties' potential guilt in a hypothetical future case. Instead, it was fulfilling its duty to expressly evaluate the defendant's arguments that the sentences should be reduced because other individuals whom they believed were associated with the events of January 6th had not been prosecuted. So I think that dispenses with it. If it doesn't, there's another precedent which she cites, which is the Watergate case itself. In that case, Judge Sirica got the original 7 defendants, and then later on, he got a number of Watergate-related he handled another number of Watergate-related matters until down the road, he also got the case of the top defendants, John Mitchell, the former Attorney General, H.R. Haldeman, and John Ehrlichman. And so what he had said in those earlier, he had expressed a belief that criminal liability extended beyond the 7 persons they're charged. And in fact, he had gone much further than Judge Chutkan ever did. He actually suggested people, names, whom prosecutors might consider calling before the grand jury. So he went much further, and the en banc DC Circuit said, no, that's nothing. So that is binding on her. It's binding even on the DC Circuit if it's appealed. So I think this is a dead issue at this point.
And we have a question from Josh that is directly related to this, which is whether this opinion can be appealed and what the procedure for it is. I assume, Roger, that the answer to that question is that it would have to be appealed either on direct appeal after a conviction, which is the cleanest way, or if they wanted to appeal it now by mandamus. But the DC Circuit would be bound by the en banc DC Circuit opinion in either case. Am I right?
I think you're right. All of that sounds right to me. And they don't even need to get to the DC Circuit case because the Supreme Court case, Leitke versus United States, 1994, I think our colleague Seraphin talked about it 2 weeks ago. That is really dispenses of this case. And, if they want to go that route, it will not delay things very long. There will not be a stay granted.
All right. Anna, let's talk about the 11th Circuit because, while we're bouncing around, we have the ongoing appeal of removal matters before the 11th Circuit. What's up with that?
Yeah, so we're still in the briefing stage. If folks remember, Judge Steve Jones of the District Court in the Northern District of Georgia, that's the federal court that Mark Meadows is trying to remove his case to from Fulton County State Court. Judge Jones decided that Meadows could not remove his case. He denied that request, and Meadows right away appealed to the 11th Circuit Court of Appeals, which is largely based in Atlanta and covers Georgia and Florida. And that is the court that will decide now, whether Judge Jones got it right in terms of sending Meadows' case back to state court. So the 11th Circuit has expedited briefing on that. That is set to wrap up today, actually. and we should be hearing pretty soon if they will set oral argument for that. But today is the day that Meadows will reply. And over the past 2 weeks, we've seen, Mark Meadows submitted his appellant brief in which he argued that Judge Jones got it wrong and basically, made very similar arguments to what he'd made before about him, qualifying for removal because he was a federal officer at the time of the conduct. He claimed that, he'd met his burden, was acting in the scope of his office, and had raised federal defenses. Fani Willis, of course, has argued that Judge Jones got it right. And the main focus here that folks need to keep in mind is that it was that second prong, the scope of office prong, that Judge Jones said that Meadows had not met his burden. He said that the charged conduct was, the heart of the charged conduct fell outside the scope of his office. But Fani Willis made sure to cover her bases in this briefing that she submitted to the 11th Circuit, because I think that she realizes that even though Judge Jones did not reach this third prong, which is whether or not Meadows raised a plausible federal defense, I think that she realizes that, even if the 11th Circuit decides that Meadows had acted in the scope of his office, she really needs to make sure to raise that third issue about the federal defenses. It's unclear to me if the 11th Circuit will reach that question. It could be the case that, they decide to reverse Jones on the scope of office, but then send it back to him to decide the question of whether or not Meadows raised a plausible federal defense, which then could send us back to the 11th Circuit. So we could have some kind of, back and forth here, possibly, depending on what the 11th Circuit decides to do with this opinion. And of course, it's also possible that they affirm Judge Jones's decision and that the case ends up back in state court. The other lingering question with removal, of course, Ben, is also whether Trump will file a notice of removal. He has not, but the clock is ticking. Steve Sadow, who is his attorney in Fulton County, has been at all of the removal hearings that I've been to for Meadows, for Jeffrey Clark, and also for the fake electors. And they have until 30 days after arraignment to file that notice of removal. I believe that the date that Trump filed his arraignment waiver and entered his not guilty plea was August 31st. So it's within the next few days here that we should see whether Trump will file that notice of removal.
And meanwhile, we have these other removal motions pending for cases that everyone seems to think are less compelling than Meadows. Who are we awaiting removal rulings from?
Right. So we're waiting to hear what Judge Jones will decide on Jeffrey Clark's efforts to remove. That hearing took place last week. And as we discussed last week, I did not think it went very well for Jeffrey Clark. I'm actually a little bit surprised that Judge Jones has not yet issued an opinion on that. He acted very quickly in getting an opinion out on Meadows' case. But here we have seen that he has not yet issued an order on Jeffrey Clark. And then the second group of defendants who are still awaiting a decision from Judge Jones on removal are the fake electors. That's Sean Still, David Schaefer, and Kathy Latham, who in a consolidated hearing all made very similar arguments, arguing that because they were electors, they were, acting as federal officers. And for the reasons I stated last week, I really am doubtful that hearing went very well for them. And I don't think Judge Jones is going to allow them to remove that case. But again, we're waiting to see what he will decide and when that order will come down. It's possible that he could be waiting to see if he could, wait for the 11th Circuit to decide the Meadows issue so that he has a little bit more direction from the Court of Appeals about, the law in this area, because there is so little law in this area. But it could also just be that he doesn't have those orders ready. Maybe he wants to hand them all down at the same time. We will see. So I'm keeping my eye on the docket for that.
All right. And speaking of now not Judge Jones, but Judge McAfee, who, for those who can't keep track of the game of musical judges, Judge Jones is the federal judge who's deciding whether to remove cases from Judge McAfee's courtroom. Judge McAfee is the 12-and-a-half-year-old judge on the Fulton County Court who is actually hearing the case. And we're all very excited about his bar mitzvah, which is coming up. Anna, he seems concerned to protect the identities of jurors, which would make him the first ever Georgia public official concerned to protect any piece of information in the Georgia court system. What is going on here?
Yeah, so Judge McAfee issued an order this week saying that the parties and media and anyone who comes into the court will be prohibited from photographing or describing any kind of identifying characteristics or features of the jurors who are ultimately selected in this case, or who are potentially going to be selected in this case. That order follows a motion from Fani Willis's office. They, mentioned that because Georgia laws around the grand jurors meant that those identities were revealed, and then subsequently there was a website that doxed their names and addresses, and there was a lot of really scary threats that were directed their way. She kind of referenced that as a reason why this would be necessary in this case. Of course, there's also the fact that Fani Willis's own team and her family have also apparently experienced threats and harassment as a result of this case. So this is kind of a protective motion that Fani Willis's team filed to ask the court to protect the identities of these jurors, and Judge McAfee granted it. I'm not entirely sure what the exact parameters of it are. Like it says, you can't make any representations or, reveal any identifying characteristics. I am not sure what that entirely means. Does it mean you can't describe physical characteristics or occupations of jurors? I would assume so, but it's a little bit unclear to me in terms of reporting on the case,
or race or gender, right? It's really typical in a lot of jurisdictions for reporters to say, the jury, which contains 6 women and 8 men, 5 black people, 7 white people, right? Like that's a completely normal, routine thing. It's kind of it's a little bit odd. I welcome the new Georgia solicitude for juror safety, but they gave out the names and addresses of the grand jurors. And it's like a little bit odd to say now you can't even describe the but here are their names and addresses.
Yeah, and that was and again, to be clear, that was required by state law. It wasn't their addresses. It was their addresses were later revealed by a website, but it was their names certainly were on the indictment, and that was because it was a requirement under state law, which I hope that the Georgia General Assembly
they need to think about that.
Yeah, but I another thing that I will just mention while we're on the subject of protecting identities and that kind of thing. There also just yesterday, Fonnie Willis's office filed a motion for a protective order over discovery in the case. And the reason that they gave, again, mentioned doxing of identities, and they mentioned the need to protect witnesses or sensitive information that could be in the discovery. And so they're asking for a protective order that would basically bar parties in the case from, disseminating discovery to members of the media or elsewhere. So beyond, preparing for the case. So it'll be interesting to see what happens with that. There is a scheduling conference tomorrow morning at 9 a.m. And I think that will be very interesting because there's a number of other pending motions and items that have been coming on the docket that maybe you want to talk about, Ben. But, just flagging that in addition to that order on jurors' identity, we now have this protective order motion that's in play as well.
Right. So actually, let's go to that. What is the contours of the protective order as requested?
Right. So, my understanding is as I've described, and I will need to go back and look at the motion to see if there's anything beyond this. But my understanding is that it generally would bar, the parties, meaning the prosecution or the defense, from disseminating basically any of the discovery that's not, especially that's not already public, to members of the media beyond, it basically restricts them to just dealing with the discovery for preparation of the case. But I would need to go back and look at that motion to make sure that I'm not missing something on whether it's more restrictive than that.
All right. So looking at Anna's background makes me want to take a trip to South Florida to the beach. So let's talk about Mar-a-Lago. Roger, the last we talked about Mar-a-Lago, you reported that Judge Eileen Cannon had requested 2 dissertations on the subject of the Classified Information Procedures Act. The University of Miami will be now awarding doctorates to 2 sets of lawyers who have, in fact, filed these SIPA treatises in front of Judge Cannon. What is the status of the SIPA briefing, which the New York Times informs me shortly before we went live has given rise to the first major scheduling conflict of the Mar-a-Lago case? So bring us up to date. Is it SIPA all the way down?
Well, there's actually a couple different SIPA things going on. But as for the treatises, they were filed. There was about 30 pages, 21 from the government and 9 from Walt Nauta, his attorney, Stan Woodward. It all seems to revolve around the question of whether Nauta and also De Oliveira, the third defendant, will be given access to these incredibly sensitive, classified documents that they aren't charged with possessing or retaining. And so the government is going to give these 32 documents to Trump because he's seen them already. Those are the 32 that are charged, the willful retention charges. They are going to give only one to Nauta because that's the one he saw before when a box toppled out.
When he spilled it on the floor of the bathroom.
Yeah. And that one is count 8. But they don't see the point in giving these documents to either of them besides that one because they have no security clearances. De Oliveira has probably never had one. They aren't charged with these documents. They're charged with moving boxes, obstruction. In any event, Judge Cannon appears to consider this a weighty and difficult question. And apparently it has to do with the term defendant, which many courts have understood. They're going to, I didn't mention, the government is going to give these documents to Woodward to Nauta's attorney. They're going to give it to John Irving, who is De Oliveira's attorney, because those guys do have clearances. They're just not going to give it to the defendants. And so the question is, there's a word in SEPA and also in other discovery about giving things to the defendant. And many courts have interpreted that to mean, okay, if you give it to the defense lawyer, that's sufficient. You don't always have to give it to the defendant himself. But those precedents, a lot of the SEPA precedents, they don't come from the 11th Circuit. They come from the Eastern District of Virginia, where a lot of these cases are brought because that's where a lot of the intelligence community is. The CIA is there. Also Brooklyn, also New York, but none in the 11th Circuit. And so this is an ongoing problem. Maybe more concerning still is that Trump on September 22nd asked for a 3-month delay in the next SEPA deadline, which is called Section 4, relates to Section 4. That deadline was coming up October 10th, and they want that delayed 3 months to January 5th. What happens in the Section 4 deadline, the government, even though the government is giving all of the charge documents to Trump, there are some additional classified discovery. There is additional classified discovery that they don't want to give to him. And so they are using under Section 4, they can, you can go, it says you have an ex parte proceeding. The government has an ex parte proceeding before the judge. Defense is not present, none of them. And you explain, here's why it's so sensitive. We want to redact such and such, or we want to substitute such and such, or how you want to handle it. And ordinarily, the other side, at the same time, the defense will sort of also ex parte go to the judge and say, look, here are our key defenses as we anticipated. So in judging what we need to, we can't say because we haven't seen the documents, but you, judge, consider these are our defenses. What's fair in terms of letting us fully defend ourselves? And they want to push that off 3 months. And if they do that, according to the government, which just responded today, clearly it would be impossible to keep the current trial schedule, which calls for a trial in May 20th of 2024. And they also feel that nothing has materially changed since she set that trial. There have been a few glitches, and the glitches are interesting. Some of them have already been taken care of. But apparently, and what they explain here is that 9 of the documents are so sensitive. These are the ones that they are turning, that these are the charge documents. 9 of the 32 are so sensitive that the agencies that originated them do not want them sent to the SCIF in Florida. They're not confident about that SCIF. They want them to be made available to the defense in a SCIF, sensitive, compartmented information facility in Washington.
Well, I was going to mention one thing that's interesting about those docs actually is it looks like 4 or 5, I think 4 of them actually may have been already in the Florida SCIF and were actually asked to remove them by the intelligence agency because they determined they were too high classified to be in that facility kind of after the fact, which is an interesting dynamic with the Justice Department, but something that can be a problem sometimes for prosecutions that involve highly classified information. You see in other cases like spy cases, where you have to have the sustained cooperation from the intelligence agency for this information. They can kind of change their position in ways that the Justice Department just has to deal with. And this appears to perhaps have been a case like that, or a case of miscommunication where the Justice Department thought it was okay to have these things in Florida, and now they're being told by the owner of those documents, I believe, as it's described in the footnote, no, we actually can't hold these in these facilities. In other cases, you have seen prosecutions get really complicated by that because you will have an intelligence agency suddenly become very uncomfortable with the way information is being framed or used, access to it, and then decide, no, we really can't share this. And the FBI can elevate that in the the Justice Department can elevate that in the interagency, but there's not always a clear way to resolve it. And usually the IC tends to win in cases like that. So it's a little bit, it's maybe a little bit of a small warning flag that you had this miscommunication in the first place. I'm sure it's something the special counsel's office is very cognizant of, very wary of. But if some elements of the IC are getting cold feet about some of these docs, that could pose a problem for some of these charges down the road, especially if Judge Cannon says, no, Trump has a right to review these things without having traveled to Washington, D.C. For a case in Florida. And that could pose its own complications.
Especially because of the nature of the further up you go in the interagency, the more people tend to be recused. So, if you elevate this above the level of the special counsel, you have the attorney general who has appointed the special counsel because he doesn't think it's appropriate for him to be involved. And above the attorney general, you have the president who says, I'm not going anywhere near this because it involves the prosecution of my political opponent. And so it's actually a very difficult issue to the extent that the agency head in question, and we don't know whether this is military or whether it's intelligence community. If it's classified at that level, it's probably intelligence community. But we don't know which agency we're talking about. Signals intelligence would come from NSA. Human intelligence comes from CIA. As a general matter, those are the two most likely. But, if the agency head and the special counsel can't work things out on that, that gets really sticky. In a case like this, it's not like, a spy case where you can kind of resolve it at the agency head level. Yes, Roger.
Yeah, there's one other thing, and it's sort of implied already. Before we got here, there was some speculation. How are they going to present these documents at a public trial? And of course, one way is you could declassify them. That's not going to happen.
Right. If you can't even send it to a skiff in Florida, you're really not declassifying it. So at least for those 9 charges.
And what that means is that they are probably planning to rely on the so-called silent witness rule, which is, well established in the Fourth Circuit, but there is no official blessing of it in the 11th Circuit. And this judge is even uncomfortable with, the protective order. It took her 2 months, and then she entered the protective order and asked for 30 pages more briefing. And so what she's going to say when we get to, and I should explain that just in a few words, the silent witness rule is a way of resolving this problem. How do you have a public trial with these ultra-sensitive documents? And the weird resolution is you do show them to the jury, but you sort of speak about them in a coded way in public in the trial. So the people watching, and particularly the media, are not supposed to be able to figure out exactly which document this is. And the jurors will have a key and they will get the whole thing. But whether this judge will permit that procedure, even though the Fourth Circuit has, is a real big question.
All right. All of which brings us to the other matter before Judge Cannon, Scott R. Anderson, which is the question of Garcia hearings. So first of all, what is a Garcia hearing? And secondly, why is Judge Cannon hung up on the question of Garcia hearings, and how many of them are we going to get, and when are they going to happen?
Yeah, so we have now 2 Garcia hearings scheduled for October 12th. It may actually be one kind of consolidated hearing because it sounds like there's some overlap, but they're both for both defendants other than former President Trump. They're scheduled for October 12th. This is a hearing we've talked about before where in the Fifth Circuit, where there's an alleged conflict of interest in regards to legal representation, a Garcia hearing is one remedy where essentially the court brings the defendant in with his attorney, explains the conflict of interest, makes a determination that the defendant, if they choose to do it once after the hearing, after they get the information, is knowingly and voluntarily waiving any concerns or potential conflicts regarding their attorney. And it's supposed to be a remedy that prevents the possibility that a conviction could later be overturned because of ineffective assistance of counsel because of conflict of interest claims. Essentially, it's confirming with an airtight case that those defendants have in fact waived their rights to have a counsel without a conflict of interest, right? In this case, the government motioned for these Garcia hearings because the attorneys for both of Oliveira and Walt Nauta, the two defendants other than former President Trump in the matter at Mar-a-Lago, both are being represented by attorneys, Nauta by Stan Woodward, Oliveira by Mr. Irving, I believe, or maybe Mr. Murrell and Mr. Irving. So maybe it's a pair of attorneys who are working together, if I recall. They are each representing, it sounds like, although there may be some overlaps or maybe less than 6, but up to 6 witnesses that are potentially going to be called by the prosecution in this case. They include the IT manager, who features in the superseding indictment, also represented by Stan Woodward, if I recall correctly. They entail a person described as being a former assistant for former President Trump, both during their time in the White House and Mar-a-Lago. I think this is likely the woman who's covered in media stories in the last week or so, indicating that she was given to-do lists on the backs of classified documents and was involved in handing some of those documents back to FBI investigators from Mar-a-Lago. She at least meets that description. And a couple other people referenced in the different superseding indictments, all anonymous at this point. We don't know exactly who they are, although we can make some informed guesses. But it's a problem because they're being represented, their attorneys that are representing them are also representing witnesses that may be adverse to their interests in this case, because they're testifying about things that seem, at least from the complaint, likely to be incriminating, or the indictments likely to be incriminating of their of their clients. So the government's getting their ask for these hearings. That's probably good for the government. The government did not get what was asked, what they had asked for, which is that they wanted the actual witnesses who also have a conflict of interest in the representation to come forward and participate in the hearing. Judge Cannon denied that, but without prejudice, meaning the government's free to make it later. If I were to be generous or to make a positive inference for what Judge Cannon might be thinking, you could imagine a structure where that makes sense, where they say, okay, let's see if Nauta and Oliveira actually are willing to waive their conflict of interests. If they're not, and they seek new counsel, then there isn't any conflict of interest with those witnesses anymore, and we don't need to undermine the attorney's relationship with them by calling them into this hearing. If they decide to stick with their current counsel, then maybe there's a case for another Garcia hearing or some other proceeding involving those witnesses as well. So we'll have to see. The fact that she did it without prejudice suggests she's not cutting off the idea. She's just saying not at this stage. We'll have to wait till October 12th to see what happens on those hearings. She also reserved the right to hold parts of them ex parte in camera, meaning that we won't hear those parts of it to deal with privilege issues. But we'll get a sense, at least, I think, some sense as to what these witnesses might be dealing with, and then how the court and the defendants are going to deal with these potential conflict issues, which are rife throughout all these proceedings because it's a fairly small universe of Trump-related lawyers. This is just the first time we've really seen defendants forced to confront them and their attorneys forced to confront them.
All right. Finally, before we go to audience questions, Scott, there is in fact a motion before Judge Chutkan not to bind, but to gag Donald Trump. And it's gotten a lot of attention. What is the status of it and what are we expecting?
So, I'm going to do this really briefly because we're short on time. We're going to talk about it, no doubt, more at length when we get a decision in the next week or two. We received the reply brief from former President Trump and his counsel in response to the special counsel's request for this gag order, essentially alleging that it violated their First Amendment rights, that they have a right to comment on the trial, really framing it in terms of hostile action by the court against former President Trump, his role as a candidate in the presidential election. Also complicating, there's a related request by a special counsel about holding off on any sort of polling in D.C. I'm assuming that's related to the trial, not related to the election. Although I don't think former President Trump's election odds in D.C. are particularly good. I don't think you need polling to tell you that. They also are objecting to kind of any sort of restraint on their efforts to polling. Maybe they're considering this in regards to building a case that D.C. is a biased jury pool. They're not going to be able to get a fair juror pool, or maybe they could arguably be using that to try and corrupt the jury pool through some kind of targeted leading polling. Although that's be a difficult enterprise because these sorts of polling don't really ask that many people that many questions. You just get a representative sampling size. Long story short, we got the reply brief. It's caused a lot of an uproar, a lot of public statements from former President Trump and his surrogates. We're going to get a final sort of reply brief or reply from special counsel, I think, on Saturday. And then we'll see what Judge Chutkan rules on this. I imagine she'll move relatively quickly because it is motivated in part by a desire to defend witnesses from intimidation, as well as jurors and other folks. So I suspect we'll see it pretty quickly, maybe as soon as next week. And we'll be able to talk about it more length next Thursday.
All right. Jacob, you have the first question today, and it is on a subject near and dear to Anna and my little hearts. So the floor is yours.
Yeah, so I'll just preface it. If people haven't listened to the interview that went up today that Anna and Ben had with the defense team for Ken Chesebro, they showed it was really interesting. One of the points that the team seemed to make was that they requested a speedy trial because they wanted Chesebro to defend himself on his own. But of course, aren't they stuck with Sidney Powell anyway, who seems to be involved in a lot more overt criminal acts like coffee counting, et cetera?
So I'll take a stab at that, and Anna, feel free to add whatever you want. So yes, they are stuck with Sidney Powell. They fought that pretty vociferously. They tried to sever from her as well. Judge McAfee didn't let them do that. The law in Georgia actually is pretty unfavorable to severance if you don't have a particularly good reason. And so they succeeded in the larger severance from the larger group, not because of a motion to sever, but because they invoked their speedy trial rights and the others didn't. And so their timing was simply different. So they were severed for that reason. They are stuck with Sidney Powell. They're clearly not pleased about that, but there are, I suspect, and if they were here, I'm sure they would say they're not pleased about that, and that's why they filed the motion. But I suspect they're not too upset about it, because while Sidney Powell's I think the technical term is a nutcase, she's involved in activity that is not really related to Ken Chesebro's activity. They've never met. They had nothing to do with each other. Whatever he did, whatever she did, is going to be hard to evaluate as related to one another. So it's almost like two separate trials that have very little to do with one another going on at the same time. Whereas if you put him in a room with John Eastman, Rudy Giuliani, Donald Trump, the argument that they're engaged in some kind of common enterprise is much stronger. So look, I mean, as I said in that conversation, I think the entire Ken Chesebro case turns on what kind of evidence the government can produce of his intent. If you just read the indictment and you just read the parts about Ken Chesebro, it is not obvious to me that they have the evidence to prove criminal intent. On the other hand, as Anna pointed out to the attorneys, there are these other things that are not mentioned in the indictment, but are potentially admissible evidence, particularly the December, I think, 8th memo that he wrote, that much more clearly bear on intent. So I think this is going to be a fascinating case to watch, and it will, at one level, be a preview of the case that Fani Willis is going to be running against the larger group. But another question it will really ask, and it'll be important to understand, is whether she has them all dead to rights or whether she was really anticipating that these cases all go together and some of them fall apart if you try them individually. And I don't know the answer to that question sitting here today. I do think if Chesebro's lawyers did not think they had a path forward with him as isolated and on his own as possible, they would not have played it the way they have. These seem like serious lawyers to me, and I think this is a really interesting trial strategy for them. Anna, what am I leaving out?
Yeah, well, you're not leaving anything out. I just wanted to say something that is a possibility that I think many people haven't realized, and maybe is not going to happen, but it's possible. When Judge McAfee ordered severance of Powell and Chesbrough from the rest of the 17 defendants, he also noted that, he was going, as to those 17 defendants, he wanted to, require them to file a waiver of their speedy trial rights, so that it's not a kind of gamesmanship situation where, they get severed and then in order to effect severance for themselves, can, just then file a speedy trial demand and basically kind of, game it out like that. So he required them to file a waiver of their speedy trial rights. But he also said that, if they don't file that waiver, they risk, automatically being put with the October 23rd trial of Sidney Powell and Ken Chesbrough. And thus far, from what I last checked, there are about 3 people who have not yet filed those waivers. I believe it was Eastman, Mike Roman, and Misty Hampton, the Coffee County election supervisor, or former Coffee County election supervisor. So we have a possibility that those folks, if they don't file a waiver, McAfee could say, okay, you're going to go ahead and be tried now on October 23rd. So just keep that in mind, that it could end up being not just Chesbrough and Powell, but maybe a few others as well. So that'll be interesting to see.
Yeah, I have not obviously spoken to the prosecutor's office about this, but I suspect they would be very happy to have a few of those if they have to go to trial in 2-3 weeks, to have a few more people at that trial so that they don't end up in a situation where they're trying effectively a whole lot of people in absentia and boring the hell out of the jury. Jim asks, this is a question I suppose for Roger. The Minnesota Secretary of State has said he thinks whether Section 3 of the 14th Amendment applies to Trump should be decided by the Minnesota Supreme Court, given that it seems like a decision by the court that Section 3 applies will modify the ballot in Minnesota because both the judiciary and the executive agree. Is the Minnesota case thus now likely to be the first to go before the U.S. Supreme Court?
Well, the Minnesota Supreme Court case, that case begins in the Minnesota Supreme Court. They've chosen a remedy that starts there. So it certainly has the best chance of getting to the U.S. Supreme Court. What the Secretary of State said was a little more nuanced and a little more confusing. We'll have to see how it plays out. He did say, you're right, that the procedure they're using is the correct one to get this to follow in this situation. And then he took no position on the ultimate questions. But he also said, it is not true that I have the power to, as Secretary of State, to decide the qualifications of people on the primary ballot. He said that is really up to the political parties in a primary. And that's a big problem potentially, because the theory of the proceeding is that you are suing an official because he has made a mistake or is about to make a mistake, and including a mistake about who he has let be on the ballot. And if the Secretary of State is saying, I have no control of that, then one could say, well, then this isn't a situation where he has made a mistake or is about to make a mistake. And so, I think the other side is going to say, well, that's a procedural bar. This is highly technical, and I have no idea, Minnesota law. But I think you're right. If any case is going to get there, this is the one. And again, you have a court that is on November 2nd, when the oral argument is supposed to take place, is going to be 6-1 Democratic appointees. Not that determines anything, but I think this has the best chance. The other one at the moment, would be the Colorado one, but that's not going to get to the Colorado Supreme Court until probably after Thanksgiving. So it's going to be a tight squeeze. And these primaries you're supposed to finalize the ballot by about January 5th.
Yeah, just a good way to answer the question, which will be the first case to get to the U.S. Supreme Court, is which is the first case Trump loses at the highest state court. Because there's no reason in the world for the Supreme Court to consider a Section 3 matter in the absence of a disqualification. And there's every reason in the world for the Supreme Court. They don't need to wait for a conflict between once any state Supreme Court says he shouldn't be on the ballot, you have a national uniformity question that the U.S. Supreme Court needs to answer. Julia, you have the next question.
Okay, my question is for Roger. When is the next hearing scheduled in Judge Chutkan's courtroom, and what issues will be addressed at that time? I located the docket for that district online and did a quick and dirty search, and I didn't see anything in Judge Chutkan's court for U.S. v. Trump from now through the end of October. What did I miss?
I agree with you. I don't think that she has said anything until the March 4th trial, but I don't think that means there won't be anything. She has set a lot of due dates, and the motions need to be due on such and such a date, and the replies and the responses and the replies. And then, if it's a complicated issue, she would then call a hearing to have oral argument. And she will probably have status conferences as well. But I think you're right as far. I don't think she's set things. And there were supposed to be motions filed, I think, October 11th. And today, Trump moved to put those off by 2 months. So there've really been a flurry of motions to put things off. And this one, which the judge wants the government to respond to by Tuesday, October 3rd, they were really quite honest about, they said, and we don't want to file all our motions in a burst. We want to do it on a rolling basis. Like do the first motion, appeal that, then do the next one, appeal that, they were, commendable, honest, candor, but they did not have a real, they did say what the three motions they were thinking about were. And of course they said, well, there's huge constitutional issues. And they're going to make an executive immunity motion to dismiss based on executive immunity. Ben's been waiting for that one.
Yeah, they're taking their time.
Yeah. One that's based on failure to state a claim. I don't know about that one. And then the third is an allegation of that the special counsel, misconduct by the special counsel during the grand jury process and the charging, the decision-making process. Certain of those, like the executive immunity, probably would require an oral argument. I don't know. But no, I agree with you. I don't think there's anything set right now.
All right. So we're going to get through the last four questions, which means we got to do them quickly. Let's do them as quickly as possible. Joyce asks, does the government expect the judge to travel to D.C. to review these docs? Answer, I think it probably does. That's what FISA court judges around the country do routinely. It may be that it's willing to make accommodations for a U.S. federal judge that it's not willing to make for a criminal defendant. But I think the likelihood is, yeah, they do expect that. Joyce also asks, there's a motion in front of Judge Chutkan from Trump's counsel to delay the SEPA hearings for 2 months while they consider several motions. What is the likelihood that she will delay this motion since there is so little classified information here? Roger, my impression is that the answer to that is close to nil. Do you agree?
Well, first of all, I might have missed that, but there was certainly a motion to delay the next SEPA. I think it was the Section 4 proceeding in the DC case also. I didn't think they gave a specific month. Maybe they did. I might have overlooked that, but I didn't see a specific date. But Judge Chutkan does want them to address that as well. And yes, you're right. There's very few documents, classified documents in that case. So it seems highly unlikely, but it's also a very opaque thing because we don't know, because it's classified documents, we don't really know much about what they're talking about. I don't, at least.
Michael, you get the penultimate question.
Hi, thank you. Yes, going back to your Chesbrough discussion, which really was very interesting, their lawyer, if I understood, their lawyers insisted at length against you and Anna that the RICO statute didn't apply because the conspiracy would have to be open-ended and it would have to aim at financial gain, neither of which they said applied in this case. And of course, that argument has nothing to do with Mr. Chesbrough being a lawyer. It's a principled argument about the law. So it raised the question, if they actually win on that, everything else goes away? Does the rest of the trials just disappear?
Yeah, if they prevail on that point, she loses the whole case.
Just the RICO charge.
Right. So the whole RICO charge goes away.
Lots of other charges.
There are lots of other individual charges, but the entire RICO case goes away. There are other bases on which Chesbrough could win that are not on matters of law and not on matters that extend beyond himself, that don't have that sweeping effect. But yeah, no, if they prevail on that motion, that's a big, big deal. Graham, you get the last question today.
Thanks. I guess this may be my question every week, is at what point does the government get fed up and file an interlocutory appeal of Judge Cannon, given that she spent all this time making the Garcia hearing decision, granted it only in part, and did so via a minute order that did not explain her reasoning?
Yeah, I wouldn't read too much into that in this particular case. I mean, Joyce probably knows better than I do, but, this is just a decision whether to hold a hearing. The most relevant determination is her determination as to whether the defendants knowingly and voluntarily actually waive, any concerns or potential conflict of interest of their attorney, that they're fully informed of them. That's a determination that's usually made as part of the Garcia hearing, as I understand it. So, the government will probably push for some sort of written determination to that effect now that they have the hearing. So we'll have to see how the hearing goes and what the decision is after that. I don't think her reasoning process as to whether a hearing is warranted actually has any bearing on, particularly now that it was granted, has a bearing on whether the defendants in question have waived their, right or not. That's going to be much more product of the actual hearing. So we'll have to wait. Those concerns may be warranted, but they're further down the road in my mind.
To your meta question, though, which is when are they going to get fed up with Judge Cannon and go to the 11th Circuit? There's a very simple answer to that question. They will go easily and breezily on SEPA matters because those are interlocutory appeals that are authorized by statute and are a normal part of the process. So for SEPA matters, they'll go when they disagree with her about anything. For everything else, they will wait and wait and wait until she does something that is that they can't live with and they can't conduct a trial under, and B, they know she is not just wrong, but wildly wrong. And then they will take her up on a mandamus and as part of that, try to get the case reassigned. But they're going to be super cautious about it because you don't want to mandamus a judge in the middle of a complicated criminal case with an ex-president and then have the 11th Circuit say something like the opinion that I think Scott probably drafted 12 times. Mandamus is an extraordinary measure not used to reverse ordinary errors or ordinary, it's a disfavored remedy. You don't want to court that opinion as every appellate clerk has had to write that. and you don't want to deal with that. And so when you take her up, you want her to get swatted back real hard, and you want to get the case reassigned. So they're going to be really patient about that. We are going to leave it there. Roger Parloff from the Ceiling Fan Room, Scott Anderson from the Blurry Peloton Room, Anna Bauer from the Garden of Read-In. Thank you for joining us today. We will be back next week. Talk to you later. The Lawfare podcast is produced in cooperation with the Brookings Institution. Our audio engineers this episode were Anna Hickey of Lawfare and Kara Schillen of Goat Rodeo. Hey folks, you need to do your part to support programs like this. If you like this program, you should be a material supporter of Lawfare so you can join the conversation and so you can support its production. Do it at lawfaremedia.org/support and join us live next time. The Lawfare podcast is edited by Jen Patja Howell. Our music is performed by Sophia Yan. And as always, thanks for listening.